Hello, I'm Hayler of Old Bailey Solicitors, and in the final video of this series we're going to look at potential pitfalls in sentence. The first category involves what we call a basis of plea. Sometimes a defendant acknowledges that they have committed an offence and wishes to plead guilty, but still disagrees with the prosecution about precisely what happened. Let's take the example of a simple assault. The victim says that you punched him 3 times to the head, and you say that there was only a single blow. Now, whether this is a significant difference will depend on the circumstances of the case, but some are far starker. For a more extreme example, let's say that the victim claims you kicked them on the ground twice, and you maintain it was a single punch with no kicks. You may still enter a guilty plea, provided you accept that what you did was an assault, but there will remain quite a difference between the two sides as to what happened. One of the responsibilities of the court is to ensure that you are sentenced on a correct basis. Where the difference between the two sides is not so great, then the court may proceed to sentence on your version. However, if the court feels that the difference between the two sides is so significant that it would make a material difference to the sentence passed, then the court must resolve the dispute. If this happens, the court may require what we call a trial of issue, otherwise known as a Newton hearing. This is similar to a normal trial and may involve both sides giving evidence. It's time-consuming, requires the attendance of witnesses, and if you lose, can lead to a loss of credit for the guilty plea that you've entered. This is not to say that you should accept an account of the crime with which you don't agree, but it is important that you understand the potential consequences of asserting an alternative basis for that plea. You would be well advised in these circumstances to take professional advice. The second category of pitfalls in sentence involves ancillary orders. In addition to general powers of sentence, the court can impose other orders for certain offences. These include disqualification from driving, restraining orders for violent or harassment offences, sexual harm prevention orders for certain sexual offences, forfeiture and destruction orders, football banning orders, and criminal behaviour orders. If you speak to the prosecutor before sentence, you may find out whether they plan to apply for such an order. Either way, it's as well to research the offence with which you've been charged to see whether the court has the power to impose one of these orders. These orders are not automatic, and you may be able to argue against one being imposed. If in doubt, get some legal advice, either from the duty solicitor at court or by finding the solicitor you want. Good luck with your case, and please get in touch if you need help.